Good morning and good afternoon to those in different time zones. My name is Dick Phillips, and I'm going to introduce this seminar on the Supreme Court's decision in Halliburton Co. In that case, the court refused to overrule its holding in Basic v. Levinson, namely that class action plaintiffs can satisfy the 10b-5 reliance requirement by a rebuttable presumption. The presumption, based on the fraud on the market doctrine, simply holds that the price at which securities are traded in an efficient market is presumed to reflect all public material information, including any material misstatements. Anyone who buys or sells securities in that market may be presumed, for purposes of class certification, to rely upon the misstatements, whether or not he or she was actually aware of the particular statement or omission. The court also held significantly that while class action plaintiffs in Rule 10b-5 actions do not have the burden of proving price impact as a prerequisite to class certification, they may rebut or attempt to rebut the presumption during the class certification process with evidence that the alleged misrepresentations had no impact on the market price during the class period. To discuss this decision with you, in addition to myself, we have Mike Eisenberg, a former Deputy General Counsel of the SEC and senior staff official for a number of years, as well as a private practitioner, and now a senior research scholar and lecturer in law at Columbia Law School, along with Stanley Grossman, the senior counsel at Pomerantz LLP, and a very highly experienced class action litigator. Mike, you want to start with the case and tell us what the Supreme Court said?
Okay. The case originates from Basic versus Levinson, which produced the fraud on the market theory, which in effect said that reliance, which is a basic, you say basic, but which is a basic part of the 10b-5 class action and regular action components, along with materiality and the other issues which are inherent in a 10b-5 case, that may be presumed if reliance was presumed if the market is an efficient market and it's a well-traded stock. And what happened then was a series of Supreme Court cases which in other areas narrowed the kind of people that would come in to take advantage of it, but the application of 10b-5 itself to a class action has never really has been challenged, but has never been successfully challenged. Well, the defendants Halliburton decided to make a broad assault. And one of the first things that they challenged was is there a private right of action under 10b in the first place? Well, the court long ago, as far back as Superintendent of Insurance and a number of other cases in the 70s and 80s, decided yes, there's a private right of action. And even Chief Justice Rehnquist, which was very reluctant about it, finally gave in. I guess it was in blue chip stamps. So that argument went by the boards. So there is a private right of action under 10b-5. Okay, if there's a private right of action, what happens when you have a class action and it has to be certified? And there were several reasons which were advanced on the part of the defendants as to why the fraud on the market doctrine does not work. The first one was their argument that it was economically unsound, that really the market does not necessarily include the real economic impact on the market of new information. New information comes out. It may or may not be included. There are some people that don't depend on it. And the court basically shut that down and said no. And the Chief Justice put it, Halliburton has not identified the kind of fundamental shift in economic theory that could justify overruling a precedent such as basic long-held precedent 1988 case.
Mike, doesn't that assume that the plaintiffs have proven that the market is efficient?
I think that they have to show, there's no question that they had to show that it was efficient. That often involves a question of showing price impact, which they have to do anyway.
Okay.
Now, the second one was an argument which also had been cut off long ago, and that was the so-called 18A argument. And what that says is that Section 18A of the 34 Act applies only to a fairly narrow band of actions, and that consequently 10b-5 ought to be read the same way and be limited, and they go through this textual analysis of why 18A cuts that off. And the court rejects that, and the Chief Justice and the opinion for the court, except for the three dissenting justices who come in as concurrences, but they're really dissents. So it's really a 6-3 opinion, although people say, well, it was unanimous. Yes, it was unanimous that the three agreed with the result, but they disagreed entirely with the rationale for how the other 6 justices got there. In any event, the 18A argument and the limitation of saying that 18A limits 10b-5 was also thrown out by the majority, and on the basis of the rationale for the Roberts part of the court saying this was stare decisis. The major theme that runs through this, we are not going to reverse a long-held opinion of the court, especially in an area like this, on the basis of disputed economic theories. He says that they had not shown that there is a supervening reality that the economics that the basic case was based on was inaccurate. That's a dispute. We don't have to decide that dispute today. What we're deciding is that this was raised before, and that you all have not raised anything particularly new, which would just, quote, justify overruling that precedent, unquote. So the two major bases for the three dissenters, Scalia, Alito, and Thomas wrote the dissent, or the concurrence, which is a dissent. So where we go now is what has been left. Well, what has been left is a very important piece of this. As the Wall Street Journal headlined that securities ruling in Halliburton is a mixed bag. Ground gained by companies looks tenuous in high court's class action decision. What they really mean by that, I think that's fairly accurate, that what they really mean by that, an essential element of the case has to do with the rebuttable part of the presumption. So the presumption that comes from basic included an opportunity for the defendants to rebut the impact of the market or the application of a class action. The court recognizes that class actions have been recognized as useful and important. The SEC has, for many years, has supported both the private right of action and the ability of class action plaintiffs.
Mike, did the court recognize it, or did they basically said that issue is for Congress, given the fact that that the court has held that class actions based on the fraud on the market theory may proceed for many years, and it is not going to ignore stare decisis. It's going to let the Congress, if it wants change, to make that change. I didn't see in the majority opinion a defense of a court action. What I saw was a reliance on stare decisis and a statement that if Congress wants to make a change, they're free to do so. And in fact, they have done so in part by passing the Private Litigation Reform Act and the Uniform Standards Act for securities litigation, but they haven't gone so far as to overturn the basic presumption.
What you say is right, and the fact that the court says, no, you can't do that, you can't turn this into a full another trial, but they say, look, the Congress has acted to correct what has been perceived as some of the bad things that go on with class actions, that they are coercive and that it costs too much and that it's really extortion and that kind of thing. They say, look, the Congress has acted, as you say, with SLUSA and with other narrowing of the scope for class actions, but that they have not. But that shows that this is not for us to decide economic theory and which economic theory is right. And you're clearly wrong on the 18A materials because that's not persuasive. And yes, let's go ahead. There is a presumption, and the real question, as has been pointed out by a number of commentators, like Merritt Scott and Jack Coffey at the Columbia blog and other places, the real question is, how far will the district courts go initially, because this has been now remanded to the district court, and it'll eventually go to the Fifth Circuit for further actions not inconsistent with this ruling, which means that there will be an opportunity of the defendants to dissuade the court from applying the fraud on the market theory because they have rebutted the presumption of reliance. The real key point to this is that the burden shifts to the defendants because the plaintiffs have already achieved what they had to do with the presumption. So the defendants have to rebut. So they have to present a case or a part of a case or basic or reasons why that does not apply for their particular case. And then when it's not settled.
Mike or Stanley, don't you think that the court made hash meat out of its prior decision in Abidjan, where it said that plaintiffs don't have to establish materiality as part of the class certification process in order for the basic presumption to apply? But now and while they didn't overrule that hearing, price impact evidence is the same kind of evidence you use to show materiality. And I've never heard of an immaterial statement having a price impact in a rational market. So haven't they, in effect, said, well, even though plaintiffs don't have to prove materiality, you can show price impact evidence, which would bear on materiality as well as on the rebuttal of the presumption.
Well, yeah, I think that's a very interesting point that you raised, Dick, because to a very large extent, of course, materiality, price impact, and even loss causation sometimes turn on the same facts. But typically, the way the plaintiffs currently present their case, and you stop me, Mike, if I'm interrupting you, but on the class.
That's all right. I'll interrupt you back. Go ahead.
Okay, good. Yeah, I mean, the way it works, of course, is that plaintiff these days on his opening papers on class certification will put in evidence of an efficient market, meaning that the market price for this particular security does absorb material information, as Dick says, false or not. The way plaintiffs will do that is they will have an expert or experts do an event study to show that when there's new information introduced into the marketplace, the market price will move in that stock in a statistically significant way, which would indicate that it's that news rather than general market conditions that have caused the price of the stock to rise. So the plaintiffs now they don't show materiality in any other way but the fact that the market has risen. Now, where you could get into an issue on materiality is sometimes the market price will not move because the false information is really meeting the analyst's expectations. So that if analysts are expecting $1 a share earnings for the year, and the price is currently reflecting that, when the company issues a statement showing $1 a share, the stock typically will not move.
But when the company's forced to correct it, doesn't the price move at that point?
In the correction, yes, but market impact is at the time that the stock is issued, not when the disclosure of the falsity, but rather during the class period when the false information comes out. Did it have an impact at that time? We look at the end of the class period, oftentimes as an indication when the price declined, that the market price was inflated. But loss causation can be different than market impact, as the Supreme Court was clear to point out in the Dura case. But the point I wanted to make was so that the market price will not necessarily move in reaction to the kind of information I was just talking about, but nonetheless you can establish market efficiency by showing other events during the class period. So the expert will show, well, okay, there were 10 other, in addition to the fraudulent statement, there were 10 other pieces of information introduced into the marketplace, and the prices did move, and that would be an indication of market efficiency without ever touching the particular misstatement on this analysis of market efficiency. So now, and again, I'll move, Mike, you stop me if I'm moving along too fast. So that's the plaintiff. The plaintiff has been doing that. He's been putting in that kind of evidence, and the defendants have been attempting to rebut the issue of market efficiency. And to a very large extent, the same kind of information that they'll use to rebut impact is the information they're going to use to show lack of market efficiency. So they will put in their experts saying, look, you have all this information that was disseminated into the marketplace, the price didn't move, it wasn't efficient. Now they'll come in with more stuff saying, okay, there was no impact. It's two sides of the same coin in many cases. But I think Ginsburg was clear to point that out in the concurrence that, well, you guys pretty much do this stuff anyway now. So there's not going to be that much more of a burden on the plaintiffs. If they have to follow through to rebut this, the defendant's rebuttal of lack of market impact.
So is this going to be an extended hearing on the issue of price impact and so that you'll have 6 experts on one side and 6 experts on another side, or will it be a summary hearing?
Well, I think it's going to be. First of all, I think the Second Circuit pointed out in its decision in Miles versus Merrill Lynch that the district court has great control of what kind of evidence to permit on the motion, the extent of the evidence, and the length of the hearing, because this is not supposed to be a trial on the merits on these issues.
Well, so let me just say that it seems to me that there's no question that the defendants will try to do what Dick says that they will try to do, and that is have a full-blown hearing on it. On the other hand, what the court says pretty much cuts the other way, that there will be an opportunity to make that presentation, and the district court will have the choice of limiting it to one or two experts on either side, because that's the certification phase. And the certification phase is looking at whether there are common questions. As you point out, this is really a mixed question. You're going to materiality. Pretty much,
the trial court always has an opportunity to prevent duplicative evidence and repetitive evidence. They can always limit the evidence on either side.
That's right.
But are they going to? Is this going to be more like a very summary hearing, or is it really going to be dispositive of the issue?
Well, I tell you, we can take some lessons from antitrust cases. In antitrust cases, for years, decades probably, the question of the impact, which is an element of an antitrust action, has been vigorously fought at the class certification stage, and courts hold many hearings. They hear experts. They can limit, as you quite rightly say, Dick, they can limit the number of experts at the hearing just as they can in trial. They can limit duplicative evidence.
But now, just in terms of what the experts do when they're going to talk in terms of with the efficiency of the market and is it well traded and so on, yes, they'll probably be able to do that. But the majority opinion here, or the 6 justices that went along, that joined in the Roberts opinion, they are skeptical, clearly skeptical of the economic argument, and if it's an overwhelming argument, a court might buy it. But if it's one of the same kinds of arguments that have been made up to now, when I've read the Halliburton ones, and they'll get a bunch of experts to do it. We've seen it in other cases. I don't think that is going to be persuasive, because those economic arguments go back and forth through the business schools, into the law schools, and it's not going to be resolved, which is why the skeptical attitude of the Chief Justice that we are going to stick by this, and we're not going to let it get out of hand. Yes, you're going to have an opportunity, and it's going to be a decent opportunity, but we're not going to let you run away with all sorts of discovery and so on.
The fact of the matter is that 99+% of the class action cases in the securities field, this is the trial. Cases do not go much beyond this. And the judges know it, and they're going to have to make a finding. And they want sufficient evidence so that they can feel comfortable about their finding. And they are the judge and the jury as far as the class action certification stage is concerned. And I don't think that in a close case that the judge will be disposed to summarize the evidence and force the parties to severely limit the nature and extent of their proof, unless they feel they've heard enough to make a ruling.
Well, now, one of the things that's very important in this is what is the purpose of the act, and what is the purpose of the authorization. The purpose of the act is to maintain fair markets in which people have confidence and that they have integrity. One of the ways in which you do that is through these lawsuits, so that if it's a close case, I would argue that that's not close enough, according to what
it's a close case. The defendants have the burden of proof in order to rebut the presumption.
That's right.
So in a close case, by definition, I would think that the defendants lose, and the case is certified.
I agree. I think that's clear. The modern jury. Federal jury instructions say that in order to rebut the presumption of fraud on the market, the defendants have to carry that burden by a preponderance of the evidence. In the Vivendi securities class action that was tried fairly recently, that was the charge to the jury. So in a close case, it's clear to me that they will lose. But I have another question to raise because there hasn't been much written on this. It's clear that at the very least, the defendants have to carry the burden by a preponderance of the evidence. I have to tell you that my understanding out in the field is that plaintiff lawyers may be looking at another standard, that in essence, the defendant's evidence to rebut the presumption should be considered similar to a summary judgment motion, and all that the plaintiffs have to show is that there is a genuine issue of material fact. Whether or not that will be the standard, I don't know, of course, but this is one of the issues that is totally open and is going to be interesting to watch.
You think it's totally open, and that the certification process and findings are akin to a summary judgment?
Well, I'll tell you, Dick, what's very interesting, all throughout the Halliburton decision, they talk about defendant has to show a lack of impact. Show. That's right. In the majority opinion, that's in the concurrence. When Robert says the issue, one of the issues that the defendant teed up was whether or not they should be entitled to show a lack of impact. So what does that mean, show? They never say proof. They say show, so I don't know what that means.
Oh, so you see lots of significance in the word show.
I do, because it's such a vague term. Before I forget, I'd like to point out that although the fraud on the market theory is essential to maintaining most securities class actions, that same theory applies in an individual action as well. If you have a large institution who brings an individual rather than a class action, he too can rely on the fraud on the market theory.
Sure.
And many institutions, of course, don't read information, particularly those who are indexing. They don't necessarily read and have individual reliance at all.
Sure. And analysts, even in the best of institutions, are fallible, and they don't pick up every piece of information when they make a decision.
That's right.
Yet it's reflected in the market.
Yeah. The other thing that's interesting, there has been a lot of litigation on the issue of what is an efficient market that plaintiff has to satisfy for the class motion. And Roberts, of course, doesn't adopt what economists call a pure market efficiency or anything close to it. He speaks of there's a well-developed market, and there's some efficiency which demonstrates that the false information is reflected in the price. That's all you need.
That has to do with the well-traded and volume on the trading exchange.
Well, that's right. I think, Mike, that there's going to be a lot of litigation on exactly what plaintiffs have to show now to satisfy the efficient market. I think it's going to be changed somewhat, or maybe changed somewhat.
Stanley, let me ask you this. Bottom line, is this going to change the 10b-5 class actions from the plaintiff's point of view? Are you going to be significant in many cases?
I think, I don't know about many cases, maybe small cases. This issue of market efficiency has really been battled out in a lot of cases. You're going to need resources because, as you gentlemen have pointed out, there's going to be a lot of experts and very expensive experts required on both sides, and defendants presumably can afford them better than some plaintiffs' firms. So it may further eliminate some players in the plaintiff's security class action. It may eliminate some of the smaller cases where, even though there may be a meritorious case, people may not be prepared to put in the resources. I was once told that I was on a panel with your former colleague, Stanley Sporkin, panel with him down in Washington, and he was critical. He said, Stan Grossman, you guys always try to bring large cases involving a lot of money. There were smaller cases, smaller corporations, and smaller losses, but people have been they've been hurt, they've been defrauded. I must say, with the expense that'll be incurred in battling this issue, people may opt not to pursue some of those cases.
Let me just say, with respect to liquidity, the increase in the volume on the exchanges, not only the daily volume but also the participants of endowments of pension funds, of state pension funds, and so on, that there are so many more people who are involved in these institutional potential plaintiffs. And the fact that there is so much in the mutual fund industry, is about $10 trillion and so on, you have a lot of people, small people, who are represented by the institution of whether it's a mutual fund or a hedge fund or an endowment or like the Erica John Fund. So the market has moved to protect more of those people, and I think in the opinion, what you see is that what's the key to this? The key is stare decisis. We're not going back. The opinion ends by saying, to maintain consistency of the presumption with the class certification requirements of Rule 23, defendants must be afforded an opportunity before the class certification to defeat the presumption through evidence that an alleged misrepresentation didn't actually affect the market price of the stock. They will have that opportunity. And I think everybody is right on this, that there will be a lot of litigation back and forth as to what that opportunity is. I'm not sure. I'm not sure a lot of district judges are going to want to sit through weeks and weeks of expert testimony when they can do it and short circuit it and be pretty sure that they'll be okay.
I think that that's an open question, and an open question is also what impact this case will have. But what is very significant, I think, as Mike and Stan have mentioned, is the influence on the chief judge of stare decisis and his unwillingness to make his court, the Roberts Court, a vehicle for radical change in existing law, at least insofar as 10b-5 is concerned. He refused the invitation of the defendants to overturn the basic presumption and thereby end for all but the largest institutional investors 10b-5 as a meaningful remedy for securities fraud. He's preserved that. He's tweaked it in order to give the defendants an opportunity to rebut price impact and the presumption, but he's retained the basic class action presumption under 10b-5.
Yeah, one of the arguments that were made on behalf of defendants is, there's internationalization, and we ought to be conform with others, and they don't go this far, and they don't have class actions, and so on. One of the basic exports that the United States has been successful with is the acceptance of insider trading as a no-no in stock trading. No one ever thought that that a French government or Japanese would fall on insider trading, or that they will. Now the OECD and the European Union and the UK and the Japanese and even sometimes the Chinese say that this, in order to protect the integrity of the market, internationalization argues for uniform standards, and that does not mean letting people get away with manipulation and with fraud.
Yeah.
So
it also doesn't mean necessarily adopting the U.S. standard, and I don't think we're going to adopt a standard that's less than what we have.
I'm just saying that
with this, I think we have to conclude the panel, but it is an important case, if not simply for class actions, but for the trend of the court, and perhaps a high mark of the Roberts Court in that it shows that the Roberts Court, as time goes on, is becoming a little more moderate in terms of reversing prior Supreme Court precedent. With that, we'll close, and I thank you all for listening.
Thank you.
Thank you.